Welcome to Firing Line. I'm Michael Kinsley of the New Republic magazine. The phrases reckless disregard and actual malice are now so commonplace that many people probably are unaware why they are so famous. They come from Justice William Brennan's majority opinion in the 1964 Supreme Court case, New York Times against Sullivan. That case revolutionized First Amendment law by giving journalists constitutional protection against libel suits. It held that a public official suing for libel must prove not merely falsehood, but, quote, reckless disregard for the truth. In the years since Sullivan, other Supreme Court rulings have expanded the Sullivan doctrine, most notably to cover all public figures, not just public officials. In a litigation-crazed society, this is a considerable blessing for the press. In other countries, journalists live in fear of lawsuits. In America, all professions except journalists live in fear of lawsuits. But fear is increasing, even among journalists, as juries award multi-million-dollar libel judgments despite constitutional protections. And there is always the prospect that the Supreme Court will reverse direction in this area like others. Anthony Lewis tells the story of the Sullivan case, its background, and its aftermath in his new book, Make No Law. Mr. Lewis covered the Sullivan case as the Times' Supreme Court correspondent. Since 1969, he has been a columnist for the New York Times. He also has taught First Amendment law at Harvard and Columbia Law Schools. He gave me a B+, which was pretty generous. Mr. Buckley, libel suits were well known to the authors of the Bill of Rights, so all the usual original intent type arguments can be invoked against the Sullivan doctrine. However, a lot of conservatives, possibly even yourself, stick to it. How do you explain that inconsistency?
I don't see an inconsistency. It seems to me that conservatives have always thought most reasonably that there is a, if you like to put it that way, a property value in one's own reputation, and that under the circumstances you can't uphold the right of property without upholding the principle that somebody has a right to protect himself against libel and slander. What I see happening, and what I don't think Mr. Lewis would object to this interpretation of it, is that you had first the incorporation of the Bill of Rights as becoming a federal responsibility, as distinguished from the responsibility of the individual states to the extent they adhere to them. And secondly, the ascendancy of the free speech principle over against the right of people to protect their good name. Is that a fair entry into the question, Mr. Lewis?
It is a fair entry, but there's an element I would add. The real essence of the First Amendment, the central meaning of the First Amendment in Justice Brennan's phrase, is the right to disagree with the government. And that's really what Sullivan was about. It has been expanded, as you've said, into, and Mike has said, forgive me, my former student, I should call you Mr. Kinsley.
Go ahead.
I did then.
Yes, you did.
But it has been expanded into the realm of non-official public figures, but essentially the case was about the right to criticize and disagree with the government. And as to that, I'd have thought, I'm confident that conservatives and liberals alike would think that was an essence of democracy, the right to disagree with the government.
Well, it's interesting. At one point in your book, you discuss the arguments that were used by Jerry Falwell, who was protesting against Hustler magazine. It had a parody, the feature of which was that he lost his virginity at the hands of his mother in an outhouse, to which the defense was offered that, after all, if they can have a picture of Washington as a jackass, why can't they have that of Jerry Falwell? So far as I know, you belabored no distinction at that point between the public figure, the public official, and the public figure. Is there one in your judgment that ought to be made?
I will tell you that I was originally skeptical and remain somewhat skeptical of the extension of the Sullivan doctrine from public officials to public figures. Because when it's about criticizing officials, it is, as I've said, about the central meaning of the First Amendment, right to disagree with the government. When it gets to the right to say rude things about people who are not in the government but are prominent, like Mr. Falwell, I find the Constitution less engaged. But we went down that road. You and I and Mr. Kinsley are all, I suppose, public figures who have to pass this barrier if we ever sue for libel. And you have sued for libel.
No, I've been sued. I've been sued for libel.
Sued.
And ours was the case in which Judge Silverman, for the first time, acceded to the arguments of our lawyers, saying that all the arguments that justified the protections given to public officials applied to public figures, and it was done, appealed, lost, so it became law. So I'm a profiteer, if you like, of your... Now, this doesn't mean we've lost the suit if we've gone to the merits of it.
No, I understand. That's...
All we did was call Linus Pauling a fellow traveler.
Right. And, of course, it wasn't just George Washington as a jackass. I loved that case. I heard the argument in the case because the American Editorial Cartoonists Association had filed a brief as a friend of the court talking about cartoons right from that one, beginning, but then through the terrible ones of Nast and as a vulture and all that stuff. And the court concluded unanimously that that was our tradition. We poke fun at famous people in this country. And I thought that was right.
Yeah, but I think there is a dispensation that attaches to cartoonists and parodists that doesn't necessarily or rightly attach to, say, commentators.
I agree with that.
Yeah, I think Herblock can say something about you that I wouldn't be or shouldn't be allowed to say.
Correct.
And that distinction, I think, ought to be preserved. But let me, if I may, ask you to comment on some of the fascinating things that you bring out in your book. At a certain weary moment, Justice White stares at the First Amendment and says, gee whiz, why ought it to be supreme? Now, this is in the context of a court, one of whose members, Hugo Black, thought there ought to be no libel law at all. If Congress says, if the father said there shall be no law, no law inhibiting, what is the
abridging the freedom
abridging the freedom of speech, then there should be no law. Therefore, there should be no libel suits whatsoever. He ran into one of those paradoxes of freedom that Sidney Hook outlined so well in his own book. But here you have a situation in which a question of a priority comes into play. How do you handle that? Why should this right transcend other rights?
You want me to defend the proposition that it should. But I'm not an absolutist on the First Amendment. I didn't agree with Justice Black, and moreover, he didn't agree with himself. Mm-hmm. He said that, but when it came to kinds of speech that he didn't like, that he thought had gone too far, he found ways of saying, well, that's not speech, or it's speech outside a courthouse, and that's the wrong place, or he found ways to get around his own absolutism. And I think, in fact, that in general, with, again, my proposition that critical speech about the government is essential. But in general, the rights of free speech, like other rights, have to be balanced against other values, like privacy, reputation.
Well, are you therefore prepared, for instance, to surprise us by saying that the CIA punished Frank Snepp in the way he ought to have been punished? But first of all, give us the background of that case, if you will.
I don't think I'm going to surprise you. I think we'll disagree. Frank Snepp was a man, an agency officer who worked in Vietnam during the war. He was, in fact, a conservative ideologically, who, at the end of the war, when the United States left, greatly regretted the fact that we left behind our Vietnamese sources of intelligence information and their names in the files where they would surely be discovered, and those individuals would be punished, as they were, badly. And he wrote a book deploring this called Decent Interval. He wrote it and published it without showing it first to the CIA censors as he had promised to do. And the government sued him, and the Supreme Court, without even bothering to hear his lawyer's argument or reading his brief, giving him a chance to brief the case, said that all the money he ever made from the book must be turned over to the United States government, which it continues to be to this day. And I regret that because I think the CIA, like other government organizations, needs a degree of scrutiny. Of course, it can have less scrutiny than other organizations, but it needs some. It needs some. And if you look I go on for a minute. If you look at the Gates hearings that just now, whatever view you take of Mr. Gates, it's been clear from those hearings that the CIA made a lot of mistakes, as any human being would in its intelligence estimates. But they never saw the light of day. There was not that corrective process that comes from mistakes being discovered and corrected.
But you're making a different point from the one I'm trying to pursue. I happen to think, A, the SNEP was right, the CIA wrong. B, I wish that the misbehavior of the CIA on that occasion had been publicized. But I'm also looking at a contract made between Frank Snepp and the CIA when he went in. And under that contract, which I myself signed in 1951 when I joined the CIA, I said, I hereby promise that under no circumstances will I reveal anything I learned about the CIA as long as I live. Now, if that's enforceable, the obvious way to enforceable, I suppose, is to make it unprofitable commercially to break it, in the same way that the courts tend to punish police officers who arrest somebody without proper papers by releasing that person. Now, here is a situation in which the right of the CIA to bind you runs up against your endorsed idea that what the CIA does is of public interest. Don't you have simply a collision here between those two rights? And why do you automatically side for the first?
I don't automatically. I agree with you that there's a collision. I think it was important, as you've just said, that the truth of what happened in Vietnam in that regard be told, and that the public know about it as a corrective measure. And the trouble...
We got congressional committees to do that, don't we?
We do now. We didn't then. We now have an intelligence committee. We didn't have...
Well, that was pre-Church, wasn't it?
Pre-Church.
Yeah.
And the trouble is that when you have a system of censorship, which is what the CIA imposed, censors tend, as you know, to take out things that are not damaging to the national security, but merely embarrassing. In fact, two former directors of Central Intelligence have published books, Stansfield Turner and William Colby, and submitted them for clearance in the approved way, and both complained afterwards that entirely anodyne passages of their books were removed, not for reasons of security, but for embarrassment.
Now, how did they handle it?
Oh, they did it in the regular way.
They submitted?
They did, and the passages that they think should have been published but weren't still haven't been published.
Okay, but let's say now that you are a judge and you are persuaded that the CIA's strict laws here were really self-serving. However, you're staring at a contract signed by this guy Snepp, in which he is simply bound. Aren't you in turn bound to side by the validity of that contract freely given, rather than the fact that you see through the motives of the CIA as being self-serving?
I don't think the judge can, I agree with you, the judge cannot look and say the motives are self-serving. But there is a point of law involved, which is in fact a very difficult one, and that is waiver of rights.
Mm-hmm.
There are some things you can't get people to waive,
Yeah.
and ordinarily constitutional rights are among them. Now, maybe you can waive your First Amendment rights because the CIA is a special kind of organization. Waive them when you join. But ordinarily, the government cannot force you as a condition for working for it to waive your rights. You can't be made to say, sign a piece of paper that says, I promise always to vote Republican if I join the government. You can't be made to do that because that's unconstitutional. So, you know, it depends again on whether the judge, the court, thinks the CIA is of such a special character that it can extract that waiver.
Well, it depends, presumably, on whether or not a comprehensive forfeiture is legal. I mean, suppose one of the things that you did the first day of your training was go to the bathroom. Theoretically, under this comprehensive ban, you can't admit having done that. Now, that becomes de minimis, right?
Yes.
But if there is the right to exact total silence in respect of an operation, especially since there are occasions when what appears to you and me an entirely trivial and innocent transaction might actually be a key to a major transaction which is imperiled by the former's disclosure. But I didn't see in any of the passages that you cited, the court or anybody else, saying that the CIA didn't have that right. Indeed, they affirmed the punishment. But you waxed indignant about it, didn't you?
Well, I do wax indignant because Frank Snepp is a person who I think had the good of the country at heart. He did violate his promise, which the court found to be a contract. But as a result, he lives a very strange life in which it isn't just the money from the book that he's lost, gross receipts, not just net, but everything. But he's under a perpetual injunction. He's the one person in our history who has been the subject and remains the subject of a prior restraint on everything he says that relates in any way to the CIA, Vietnam, and so forth. So when he wants to make a speech, he has to clear it. He reviewed a book for the Los Angeles Times. He had to send the review to the CIA first for clearance. It's a very odd life.
Yeah, that seems pretty draconian. Now, would he be in contempt of court if he failed to submit that speech?
He would.
And would that be a separate cause of action if that order, if he were penalized under that mandate?
Well, it would. Let me give you another example, which is, I think, impressive in its absurdity. Another man named Victor Marchetti, who, unlike Frank Snepp, was very antagonistic, formerly worked for the CIA, was very antagonistic toward it. He was a subject of a lower court injunction. Snepp's the only one who's had this prior restraint by the Supreme Court, which required him to clear everything he said. He made a speech somewhere in the course of which, not in a prepared speech, but in the course of a colloquy with the audience, he spoke about a CIA program, scientific program some years earlier, to plant tiny transmitters inside cats and then to somehow get the cats into the Kremlin, where they would broadcast, presumably only to cat-loving communists. And the government complained, went to the judge who had issued the order, Judge Bryan in Virginia, that he had violated the injunction by not clearing this first. And Judge Bryan wisely wrote a note to the attorney at the Justice Department saying, "Do you really want to pursue this?" And they dropped it.
And they did, yeah. Yeah, there is a moment, I suppose, in which they it becomes so much of a burlesque that they shy away from it. But comment, if you will, on the alternative that at one point Justice White thought out loud about. One wonderful aspect of this book is that Mr. Lewis had access to the private journals of Mr. Brennan, and therefore can give us some of the flavor we couldn't otherwise get. The size of these judgments is probably the most intimidating aspect of them. What is to prevent you from recommending a limitation on judgments such that you could, on the one hand, hope to restore your reputation by getting a $1 judgment plus costs, on the other hand, not run the hazard of being simply impoverished?
I don't want to amaze you too much, but I have in fact recommended that. I was part of a commission that made some proposals for libel reform, and the main proposal was that as an option to as an alternative to the ordinary libel suit, there be a suit for no money damages, solely for purpose of clearing your name, and the winning party would get attorney's fees from the losing party.
That's very much against common law, isn't it?
It's against the law in this country. It's the British system.
Yeah.
We don't have that.
No. It's a British system to make the loser pay all.
Yeah.
But it's very much against common law to say zero damage.
Oh yes. That would be an entirely new proposal.
Yeah. Now, this was received how?
Badly.
Now, why?
The press didn't like it because...
Why wouldn't the press like it?
Well, because as the price of getting this damage-free action, the press would have to give up the Sullivan protection, and the only issue would be truth. There would be no longer any issue of
malice,
of reckless disregard, what the publisher or the reporter knew at the time, Did he know it was probably false? None of that would come in.
But all they would stand to lose, on the other hand, is the cost of litigation.
I agree with you, and that's why I thought it was a fair proposal. But then on the other side, the plaintiff's lawyers, of course, didn't like it because they like to have the big damages of which they get a substantial percentage.
You know, in South Africa, everybody belongs to one of those press institutions in whose hands complaints rest, and the only penalty that they can inflict is that they can require the paper, if they rule against them, to give exactly equal space to their apology. Saying sorry. Does that make sense to you, or would it be impossible under the First Amendment to force subscription to that code or any other code by all newspapers?
The commission that I was on ducked that very. I thought it should be, if a newspaper was found to have published a falsity about an individual sued under this system, I thought the newspaper should be required to publish it. But it was questionable under the First Amendment whether you can compel a newspaper to publish something it doesn't want to. So we
Well, you can make it an alternative, can't you? That is to say, the judge can say, publish it or pay $1 million.
Well, we didn't think of that, maybe. That would concentrate their minds wonderfully.
Well, in principle, is this something that you think would advance the... What are we after? We're after the right of an individual to survive an onslaught by a newspaper that gets facts screwed up. And on the other hand, we want a maximum freedom of robust thought, et cetera, et cetera. Therefore, oughtn't we to seek out an avenue by which those two become possible, which we haven't discovered?
I think limiting damages, either under this system of no damages or a strict limitation, is a wise course to achieve the balance that you're talking about. If it happens, it's going to happen. It can only happen by legislation. Some state is going to have to experiment with it. That's what we suggested. It isn't a constitutional doctrine.
Connecticut has, you know.
Limiting damages?
Yeah.
I wasn't aware of that.
Punitive damages are limited to the cost of litigation if the defendant apologizes.
But the other kinds of damages, general damages, no limit.
No limit. No.
Well, of course, juries...
But there shouldn't be, should there? I mean, if you lost $1 million contract, then there should be $1 million damage.
Yes, but that's another matter. Juries are free now to give money not only for that, and that the lawyer's term for that is actual damage, provable loss, but also for pain, sympathy, suffering, in limitless amounts. We're talking about $25 million, $100 million verdicts.
That's ruled out in Connecticut.
I see. I think that's a good system.
It is good. So the process would be to have to try to get the American Bar Association and other interested parties to advocate such reforms as a matter of political fact or commercial fact, would they?
I doubt it.
So pressure has to come from the clerics, eh? That's you.
Well, I tried. I did what I could, but you know, the lawyers weren't interested.
But if would you be willing to give up Sullivan if such reforms were instituted?
For that kind of a damage-free action, yes, I would.
And do you predict that there will be no further movements within, at least the current court, to move in the direction of Hugo Black, that no libel suits are justified at all?
I actually think that on most First Amendment issues, and to me this case isn't just about libel, though, you know, that's what we're talking about. It's about, in general, the right to differ with the government. I think that on most First Amendment questions, the current court is at a point of repose. I don't see radical change, certainly not change to expand the freedom, because we're not in that mood on the court now. But I also think that probably we're mostly at a point of repose the other way, too. I think they're pretty well content with it.
We're at a point of repose, too, I'm afraid. Mr. Buckley, the Constitution does say no law, make no law abridging the freedom of speech. Conservatives are supposed to believe in strict construction. Doesn't that lead you to if not an absolutist view of the First Amendment, shouldn't that lead conservatives to a more absolutist view than they often take?
No, I don't think so, because as Sidney Hook pointed out, a reading of that kind makes the whole instrument incoherent. I have a right to summon witnesses for my defense. You have a right not to testify. So something has to yield in a situation like that, and in a dozen other situations. Does that law keep a state from acting enacting anti-obscenity laws.
Oh, sure.
Time and time again, it has been said no, it does not.
Well, there's clearer cases than that. You can pass a law saying you can't say I'll pay you $5,000 to murder my brother. That's a limitation on speech.
That's right.
But the point is, shouldn't it lead you to be more receptive to extreme absolutist versions of the First Amendment, interpretations of the First Amendment, if you are in fact or attempt to be as strict a constructionist as possible?
I don't know a conservative who feels that any of the founding fathers was able to project his thought into every situation that would arise, for instance, electronic communications. So that I would have very little respect for anybody who assumed that you could decoct from the language of the First Amendment exactly what was and what was not a illicit law. Would you agree?
I agree, especially because there was virtually no debate on it, and there's not much evidence what they meant by those words in terms of specific examples.
Yeah. Well, I have a closing ceremony. With infinite regret, this is the last of Michael Kinsley's scheduled appearances as the examiner, and I have a souvenir for him. The idea is that every time he is tempted to burn the American flag, he should consult this, and viewing the dollar bill, he should remind himself this was the country that gave us supply side, and under the circumstances it exists.
I'll treasure it
Michael,
always.
we'll miss you.
Thank you. Thanks, Bill. Mr. Buckley, Professor Lewis, thank you.
Thank you, Mr. Lewis, author of Make No Law, Mr. Kinsley, ladies and gentlemen of St. Thomas Aquinas.
Next week on Firing Line, William F. Buckley Jr. and Michael Kinsley take a nostalgic look back at 25 years of Firing Line, commenting on excerpts from programs with Norman Thomas, Timothy Leary, Muhammad Ali, Claire Booth Luce, Margaret Thatcher, Ronald Reagan, and George Bush. Funding for Firing Line was made possible by a major grant from the John M. Olin Foundation, Incorporated. Additional support was provided by the Annenberg Foundation.